Bar admissions, we are looking at really 5 areas. The first is multi-jurisdictional practice on the domestic side, MJP on the international side, alternative business structures or forms of ownership of law firms by non-lawyers, alternative service providers, which you heard Jerry make mention of, and the uniform bar examination. So let me take those in reverse order. The uniform bar examination, which is known as the UBE, was first administered in 2011. There are now 14 states that administer the UBE, mainly concentrated in the west and Midwest part of the country. Washington State, Idaho, Utah, Arizona, Alaska, Montana, Wyoming, Colorado, North Dakota, Nebraska, Minnesota, Missouri, Alabama, and New Hampshire. And what the uniform bar examination is what its name implies. It is a uniform bar examination that gives you a portable score. It has nothing to do with your status as a lawyer. But if you take the examination and pass it, you do have a score that you can move from jurisdiction to jurisdiction without having to retake the bar examination. States that administer the uniform bar examination still are in control of character and fitness for their particular state. They also determine the passing score for their particular state. And I'll tell you that in 2010, the Uniform Conference of State Chief Justices did pass a resolution endorsing the concept of the uniform bar examination. Also, the American Bar Association section of legal education and admissions to the bar also passed a resolution in 2010 endorsing the uniform bar examination. So where does Florida stand? And by the way, I should say that all our committee or all our board can do is study these issues and make recommendations to the Supreme Court. We don't have the ability, obviously, to change the rules of admission for the Florida bar. So I want to make sure that's very clear. Florida Board of Bar Examiners has been involved in our discussions and will continue to be. As you all know, the main thing that is driving all these issues of reciprocity, admission on motion, uniform bar examination, is the increase in mobility of lawyers. It's an issue that is not going to turn itself around. You know, we are now in a new paradigm, and our profession has become more mobile. I, for one, have worked in a law firm, a national law firm that had multi-city locations, and in the short time, well, I should say short, it's not short anymore, 25 years I've been in Tampa. I recall moving to Tampa in '88, and it was a very large deal when a Detroit law firm named Dykeman Gossett moved to our city, because I recall it was probably one of the first firms to have a presence in Tampa. In today's market in Tampa, there are now only 3 law firms of 50 more lawyers that are based in Tampa. It's pretty remarkable. And those firms are my firm, Scriven, Hill, Ward, Henderson, and Gray Robinson, are the only firms that are based in Florida. Every other firm in our city that is 50 more lawyers is actually a regional or national law firm. So we're in an age now of mobility and multi-jurisdictional practice. The second issue I want to just make a brief mention of is this whole issue of reciprocity. Reciprocity is really twofold. The first issue is what is called admission on motion. States that recognize admission on motion allow lawyers to become members of that state's bar without taking the bar examination. There are now 38 states that recognize admission on motion. And of the 38 states that recognize admission on motion, 24 of them require or only recognize admission on motion based on reciprocity, which means that you cannot waive into those states unless your state also permits admission on motion. And so Florida clearly is in its own ecosystem, but I don't know where this is headed for a fact, but my suspicion is that the days that we will not be a state that recognizes admissional motion are probably fewer than the ones that are behind us. Again, just because we're in a mobile age now. Something we're studying, one of the big issues in this area has been if we adopt a uniform bar examination and we have admissional motion, will it somehow denigrate the quality of Florida lawyers and their knowledge of Florida law? I attended a conference put on by the National Conference of Bar Examiners a few months ago, and one of the issues that states that have been administering the UBE were discussing was how lawyers have been integrated into their states, and remarkably, or perhaps not, none of those states said that administering the UBE has been an issue in terms of lawyers' knowledge of their own jurisdiction's laws. Some states have an online requirement that you take a course if you are coming in under the UBE, and some states don't worry about that and just administer the UBE. And keep in mind the UBE is composed of 3 components, one of which is the MBE, which Florida already recognizes. Next issue we're looking at is this issue of alternative service providers. And again, this is something that has already been made reference to. I believe it was Jordan that made mention of this 85% below the waterline, and states looking for a way to bridge that gap and to provide services or to make legal services more accessible to non-lawyers or to clients. And one state, the state of Washington, in 2012, passed a new admission rule under which they license a new category of, I call it paralegal. The technical term is limited license legal technicians. These are essentially paralegals that are allowed to provide services directly to the public without the supervision of a lawyer. The first area approved for that new practice area or designation is family law. California, I believe New York are also looking at some form of alternative service providers. And again, this fits into the new paradigm where I believe there are going to be a lot of, I'm not sure I call it breaches anymore because it's just what we are now, but other forms of services, other ways that consumers have access to the legal market. I just read an article that in May of this year, Walmart stores in Toronto are now offering legal services. And so we thought about, many years ago when you go to, a drugstore and be able to get a physical, and that's now routine. And, you think about the medical profession, and those of you that maybe have needed a prescription at the last minute, you know how difficult it is to see a physician. You can sometimes have to wait months. But, physicians' assistants and the medical field have greatly, I think, increased access to medical services. So, again, these are all things we're looking at for the Florida Bar. And the last thing I've mentioned, and I would say from our committee standpoint, has gotten the least traction, is this concept of alternative business ownership. Firms in Australia, some law firms in Australia and Europe do provide for ownership of law firms by non-lawyers. I would not say that is a non-starter in the U.S., but in terms of the immediate changes, I would say that's one that our group just has not been enough study out there on that issue for us to feel at this point we're going to make any probably immediate recommendations on. But again, that's something out there, and as we move toward more global economy, that could eventually work its way to the U.S. Only one territory so far permits that, and that is the District of Columbia.
Thank you, Lance.